Chief Justice, there's been a lot of talk around judicial reform of late, and I know we don't want to get into the specifics of anything because, some things could be still under investigation, some matters could be sub judice. I just want your 35,000 feet view on judicial reform. Is it a good time to have this debate in this country? You were part of, various judgments which talked about judicial reform. There is a view that, something needs to be done. I want your 35,000 feet view on whether it is an apt time to have that debate in this country about whether some certain things need to be reformed in the higher judiciary.
35,000 feet above sea level, when you have an air pocket, the pilot tells the passengers to fasten their seat belts and navigates that air pocket. Now, there is something to learn from that, and that's something which I have learned over, years of being in the judiciary and before that as a lawyer, which is never take decisions which are reactionary. When you have a problem on hand, deal with that problem on hand. Allow the dust to settle. Have a broad stakeholder consultation, a broad reflection on what needs to be done, and then take decisions which will be in the interests of the institution and the nation. Never take decisions on the spot because you may be reacting to a situation and your decision would be a decision which may not be well thought of. Talking of judicial reform, I think reform has to begin at the very base of the pyramid, namely the district judiciary, because that's where common people come into contact with the judicial system. A young couple which has a matrimonial dispute, where do they go to? They don't go to the High Court or the Supreme Court as a matter of first instance. They go to the family court. Now, you see that in the family courts, there's a huge backlog of cases for the reason that we have used the adversarial system for resolving family disputes, which is so completely incorrect. Family disputes have to be resolved by applying non-adversarial systems because you have a child. If the couple has a child, there are issues of child custody, of child welfare. So we have to adopt a more non-adversarial system at the level of the district judiciary. The second important reform which we need to focus on is the huge vacancies in the district judiciary. Recruitment to the Indian district judiciary takes place in the states. It's never at the national level. I am a proponent of at least some national deliberation taking place on should we have an all-India judicial service in India. In other words, we must make some effort to attract the best into the Indian judiciary at the district judiciary level. Apply reservations. Now, the states do have some concerns because we are a federal nation. So will having an all-India judicial service impact on the responsibilities, the authorities, the constitutional role of the states? That has to be obviously thought of, and I don't discount the concerns of the states. But having said that, we can at least have a national level examination and then allow for recruitment by the states on the basis of the merit list in the national examination, applying reservations in relation to each state, whether for the SCs, the STs, or the OBCs, as the case may be. So that reform has to take place at the lowest level. Just one final word on this question, which is that the government, the state, is the largest litigator in Indian courts. The largest volume of litigation into Indian courts comes from the government. Now, I think the government has to rethink its policy on litigation and reduce the amount of litigation which governmental agencies take resort to. If that is done, you will find that more and more efficient means of resolving disputes take place. Unfortunately, we live in a culture of distrust where, the ordinary feeling is of every officer, say at the middle level or a senior level in government, go to court. If the court tells us to do it, well, we are protected because the court decided in a particular way. I think we have to answer that and allow for less and less disputes to go to litigation and allow for less and less disputes to go to trial. I saw, for instance, in the Supreme Court that every case goes to an oral hearing. Even a case where, say, 3 courts are in agreement with each other. We are probably one of the few Supreme Courts in the world where oral arguments are the predominant method of resolving disputes. Should we have reliance on oral arguments to that extent? Because they place a burden on the productive time of the courts. Then which are those cases where you should have oral arguments? Which are those cases where you should not have oral arguments? Some serious conversations across the nation on these aspects is necessary, because we now have gathered experience over 75 years of the functioning of the judiciary. And there has to be a broader national dialogue on these critical issues which face the Indian judiciary to make it a more efficient judiciary, because unless we do so, the judiciary will not really, in that sense, be able to be a critical component in the advancement and the development of the nation. The judiciary is a very key aspect of rule of law. So when you speak, for instance, of getting more business into India, investment into India, what does investment need? What does global investment need? Or domestic investment need? Global or domestic investment needs a climate where the law is certain, the law is objective, the law is applied in a transparent manner, and disputes can be resolved efficiently. So, reforming the judicial system in that sense is going to be a key element in the overall progress of the nation to being truly a developed nation, both economically and socially.